$2.4 million. That's what an independent valuation firm later said my company would have been worth in year 3 if I had launched it the way I designed it, under my name, with my patent, with my product on the shelves of the stores I'd already lined up. Instead, on a Tuesday morning in March, I opened LinkedIn and saw a press release with a stranger's face on it, standing next to my product. Same silhouette, same click-lock mechanism, same 3-color packaging I'd mocked up myself at 2 in the morning, fueled by gas station coffee and the kind of hope you only have before anyone's had the chance to hurt you yet. The headline read, "Local entrepreneur Vanessa Cole launches revolutionary new product, secures 6-figure seed round." I remember the coffee mug in my hand going lukewarm and then cold while I sat there, scrolling, rereading the same 3 paragraphs of that press release over and over, waiting for my brain to produce some alternate explanation that made this make sense. Maybe it was a licensing deal I'd somehow forgotten agreeing to. Maybe it was a different mechanism that just happened to look identical from a low-resolution product photo. I actually opened my own pitch deck files side by side on my second monitor next to the press release photo before I let myself fully accept what I was looking at, because some part of me needed it to see it disproven rather than confirmed. It didn't disprove itself. It confirmed itself, slide by slide, detail by detail, until there was nothing left to explain away. My hands went cold before my brain caught up, because I knew that product. I had built that product. I had put it in a pitch deck, 31 slides, 11 months of my life, and every trade secret I had, and I had handed that pitch deck to Vanessa Cole myself in a conference room because she told me she wanted to help me get it funded. She didn't help me get it funded. She filed a provisional patent application on it herself, 8 days after our meeting. This is the story of how I found out, how I built a case the United States Patent and Trademark Office and a federal judge could not ignore, and how a woman who thought she'd made a clean getaway with my life's work ended up writing me a check with more zeros on it than she ever expected to pay. She thought she got away with it. She was wrong. I'm not going to give you her real name. I'll call her Vanessa Cole, because that's close enough, and because what matters here isn't the specific person, it's the playbook. Because if you have ever built something, invented something, written something, designed something, and you've ever had to trust someone else with it before it was protected, a business partner, an investor, a mentor, a friend of a friend who knows people, this story is for you. Today's story is about greed, betrayal, and the process of getting every single dollar back, plus interest, plus legal fees, plus a public reckoning she never saw coming. I documented almost everything as it happened, because somewhere around week 3 of this nightmare, I stopped being just a victim and started being a detective. I kept the emails, I kept the timestamps, I kept the metadata. And when the United States Patent and Trademark Office, and eventually a federal court, looked at what I'd collected, there wasn't much for Vanessa Cole to argue. I've told financial betrayal stories on this channel before. The contractor who drained an elderly client's retirement account, the financial advisor running an affinity fraud scheme through his own church congregation, the business partner who quietly redirected client payments into a shell company for 3 years before anyone noticed. Every one of those stories ends the same way I promise you this one will, with the person who thought they'd gotten away clean discovering, usually far too late for them to do anything about it, that someone kept better records than they ever imagined possible. If stories like this are the kind that keep you up at night in the best way, the kind where the person who thinks they're smarter than everyone else finally meets a paper trail they can't talk their way out of, subscribe, because I tell these every week, and this is one of the most satisfying ones I've ever lived through myself. Mostly because, unlike most of the stories I tell you, this one happened to me. Let's go back to the beginning, because the beginning is where I made the mistake that almost cost me everything. Before I tell you about the idea itself, I want to be honest about where I was financially, because I think it matters for understanding why I made the choices I made, and why someone like Vanessa Cole knew exactly which founders to target. I wasn't desperate, but I wasn't comfortable either. I had about $31,000 in savings, split between an emergency fund I'd promised myself I wouldn't touch, and a smaller opportunity fund I'd been building for 2 years specifically to seed a business idea if the right one ever came along. I was still working my product design job full-time, which paid decently, around $92,000 a year, but it also meant every hour I spent on the Vela clip was an hour carved out of evenings and weekends, competing with sleep, competing with everything else in a normal life. I didn't have money for a full legal team from day one. I didn't have a co-founder to split the workload or the risk. I didn't have a wealthy family member who could write a check to cover a full, non-provisional patent filing without a second thought. What I had was a good idea, a functioning prototype, a stack of manufacturing quotes I'd assembled through persistence and a lot of unanswered phone calls, and a limited runway to turn all of that into something real before my savings ran out or my day job started to notice how distracted I'd become. That combination, genuine promise but genuine resource constraints, is, I now understand, exactly the profile predatory operators like Vanessa Cole look for. Not someone with nothing, because someone with nothing usually doesn't have anything worth taking yet. Someone with almost everything, except the one thing, capital or connections or legal protection, that makes them willing to hand over their most valuable asset to a stranger who promises to fill that gap. My name is, well, for this story, let's just say I'm the narrator. And I was 34 years old when I designed what I called the Vela clip. If you've ever dealt with reusable food storage, the kind where you're wrestling with silicone lids that never quite seal or bulky plastic containers that eat your cabinet space, you know the problem I was trying to solve. I'd worked for 9 years in product design for a mid-size consumer goods company, and I understood injection molding. I understood tooling costs. I understood retail margins. What I didn't understand, not yet, was how vulnerable an idea is in the 11 months between "I've solved this" and "I own this." The Vela clip was a modular, stackable, one-handed sealing system. It used a cam lock mechanism I'd sketched on a napkin in April, refined over the summer, and had a working prototype for by October. I filmed my nephew testing it one-handed while holding a toddler on his hip, and that video became the centerpiece of my pitch deck. 31 slides, market sizing, unit economics, a manufacturing quote from a factory in Ohio I'd already gotten on the phone twice, photos of the prototype, and on slide 14, a full technical breakdown of the cam lock mechanism itself, the actual secret sauce, the thing that made it different from every other product on that shelf. I had put a provisional patent application in progress. I'd started the process with a patent attorney in September, but provisional applications are inexpensive, and I hadn't yet filed the full non-provisional application because I was trying to conserve cash for prototyping. That gap between started and filed is where this entire story lives. I want to name something plainly here because I think it's easy to romanticize an inventor's journey after the fact, once there's a happy ending attached to it. At the time, none of this felt romantic. It felt like a second full-time job stacked on top of a first one, done in stolen hours, funded out of my own modest savings, with no guarantee that any of it would ever amount to more than a well-organized folder of prototypes I'd eventually stop looking at. I mention that only because I think the people most vulnerable to what happened to me aren't reckless dreamers. They're careful, hard-working people who've already done everything right except the one thing, the legal protection, that costs money they're still trying to save up. I met Vanessa Cole at a small business pitch night in a co-working space downtown, the kind of event with name tags and a cash bar, and 40 people all pretending they weren't nervous. She introduced herself as a startup advisor and angel investor, and she had a way about her, polished, warm, immediately interested in exactly what you were doing, like she'd been waiting her whole career to hear your idea specifically. She told me she'd helped 3 other founders get funded in the last 2 years. She dropped names of accelerators. She talked about a network of family offices she worked with. She asked sharp, specific questions about my unit economics that made me think she actually understood consumer products, which, looking back, she did. That was never the problem. The problem was never that Vanessa Cole didn't understand business. The problem was that she understood it extremely well, and she'd apparently decided a long time ago that the fastest way to succeed in it was to let other people do the inventing. Over the next 6 weeks, she took me to coffee twice, texted me articles about the reusable packaging market, and asked me to walk her through my full pitch deck so she could see where the gaps were before she introduced me to her network. She never asked for equity, she never asked for a fee. She framed everything as mentorship, as generosity, as her simply liking me and wanting to see me win. In hindsight, that generosity was the hook. I remember one coffee meeting in particular in late February where she asked to see an updated version of my slide deck because her investor contact had specifically asked about unit economics at scale, cost per unit at 10,000 units versus 100,000 units, retail margin assumptions, that kind of detail. I remember feeling genuinely grateful in that moment because I'd been struggling to model those numbers convincingly on my own, and she spent almost 45 minutes walking through spreadsheet assumptions with me, asking sharp questions, suggesting I model a mid-tier scenario at 50,000 units that I hadn't considered. It felt, at the time, exactly like what a good mentor is supposed to do. It felt like someone was, finally, genuinely in my corner. I want to be honest that even now, knowing everything I know, I don't think that particular meeting was performative on her part in every respect. I think she may have actually found the unit economics puzzle genuinely interesting to work through, the way a good chess player enjoys a hard position regardless of whose game it is. That's part of what made her so effective, and part of what makes this kind of betrayal so disorienting to recognize in real time. The help can feel completely real, moment to moment, even when the underlying intention behind offering it is not. I want to walk through these specifically, because if you're watching this and you're early in building something, I want you to actually clock these the way I wish I had. First, she never signed anything. I mentioned, almost in passing, that I usually asked people to sign an NDA, a non-disclosure agreement, before I shared the full technical details of the Vela clip. She laughed it off warmly and said, "Oh, I never signed those. I've been burned by lawyers wasting my time on paperwork instead of actually helping founders. If you trust me, you trust me." I remember feeling almost embarrassed for having brought it up, like I'd insulted her. That embarrassment cost me, eventually, 6 figures in legal fees to undo. Second, she asked for the full deck before any real commitment existed. Real investors, real advisors, they'll often look at a summary, a teaser, before they ask for the complete technical breakdown. Vanessa wanted everything, immediately, including the manufacturing quotes and the CamLock schematics before she had made a single concrete offer of help. Third, she kept steering conversations toward what if we did this together language, without ever formalizing what together meant. No term sheet, no advisor agreement, no equity discussion with numbers attached, just warm, vague, aspirational language about partnership. Fourth, and this is the one that haunts me most, she asked me twice whether I'd filed my full patent application yet. Both times I told her honestly that I'd only filed the provisional and was waiting on funding to cover the full non-provisional filing costs, which my attorney had quoted around $11,000 with attorney's fees included. She nodded sympathetically both times. I now believe she was checking a clock only she could see. Before I get to that final meeting, I want to walk through what actually went into that prototype because I think it matters for understanding the scale of what was taken, and because it's the part of the story that was, honestly, the most fun before any of the rest of it happened. I built the first working version of the cam lock mechanism out of a combination of 3D printed PLA plastic components and hardware store springs, working at my kitchen table most weeknights between roughly 8 and 11 at night. I went through 11 distinct design iterations before I landed on the geometry that eventually became the Vela Clip's signature mechanism. The 10th iteration actually worked fine mechanically, but failed what I called the one-handed test because it required too much thumb pressure to disengage, which defeated the entire point of the product for anyone with limited hand strength or dexterity, a consideration that mattered to me personally because my grandmother, my actual grandmother, not the fictional one Vanessa would later invent, had arthritis, and kitchen tools that required strong grip strength had always frustrated her. The 11th iteration was the one that worked. I filmed my nephew, who was 7 at the time, sealing and unsealing 5 different container sizes one-handed while holding a stuffed animal in his other arm, just to prove the concept worked for someone with small hands and no particular strength. That video became slide 9 of my pitch deck, and I remember Vanessa specifically commenting on it during our meeting, saying something like, "This is the kind of demo that actually sells a product. You can't fake this kind of proof." I took that as a compliment about my presentation instincts. I now understand it may also have been her recognizing in real time exactly which asset she intended to take. Because it represents actual hours, actual trial and error, actual engineering judgment, the 11 iteration process that led to a specific, protectable implementation, not just a generic idea anyone could have landed on by thinking about cam lock latches in the abstract. On a Thursday afternoon in early March, I sat across from Vanessa Cole in a glass-walled conference room she'd booked at a co-working space, and I walked her through all 31 slides of my pitch deck. I emailed her the PDF afterward, at her request, so she could review it more carefully before our call with her investor contact. The email is time-stamped 4:47 p.m. I have it. I will always have it, because it became Exhibit A. She thanked me, she said she was genuinely excited, and would circle back by end of next week with feedback and hopefully an introduction to her contact. I never heard from her about an introduction. 8 days later, she filed a provisional patent application listing herself as the sole inventor of a modular sealing apparatus with cam-actuated locking mechanism. 8 days. I didn't know that yet. For the next several weeks, I just thought I'd been ghosted by someone flaky. I sent 2 polite follow-up emails. She responded once, vaguely, saying she was still working on it internally. Then silence. There's one exchange from that final meeting I've replayed more times than I can count. Near the end of our 90 minutes together, Vanessa asked me almost casually while flipping back to slide 14 on her laptop, "Do you have this documented anywhere else? Like, is there a version history, engineering notes, anything like that? Or is this deck basically the whole thing?" At the time, I took it as due diligence, the kind of question a serious investor asks to gauge how buttoned up a founder is. I told her honestly that the deck represented the most current and complete version, but that I did keep dated notebook sketches going back to the spring, mostly for my own reference. She nodded, made a note on her own legal pad, and moved on to asking about my manufacturing timeline. I didn't think about that exchange again until almost a year later, sitting in my attorney's office, when she asked me to describe in as much detail as I could remember exactly what Vanessa had asked me during our meeting. When I got to that question, "Is this deck basically the whole thing?" my attorney stopped typing and looked up. "That's not due diligence," she said. "That's someone checking whether there's a paper trail that predates the theft that they'd need to account for." I didn't want to believe that interpretation at the time she said it. By the end of the case, I no longer had any doubt she was right. I had no idea at that point that internally meant her own new company. I had no idea that the woman who told me she'd been burned by lawyers had in fact retained one of the more aggressive patent attorneys in the state to move as fast as possible on a filing built entirely from my slide 14. That silence lasted about 5 months, and then on that Tuesday morning in March of the following year, the press release found me first. I think it's worth pausing here because I've told this part of the story to friends since, and the question I get most often is, what were you doing during those 5 months? Didn't you notice anything? The honest answer is complicated. I wasn't idle. I kept refining the prototype. I kept talking to that Ohio manufacturer, trying to negotiate a smaller minimum order quantity so I could self-fund a first production run without needing outside capital at all. I applied to 2 accelerator programs and got rejected from both, politely, generically, the kind of rejection email that tells you nothing about why. I remember specifically wondering during that period whether one of those accelerators had somehow already seen a similar product and passed on mine because of it. I had no way of knowing at the time that the accelerator hadn't seen a similar product from someone else. They'd simply never had a reason to know mine existed as anything other than a deck sitting in an inbox somewhere. I also, and this still stings a little to admit, defended Vanessa to a friend during that window. My friend Priya, who I'd told about the pitch meeting, asked me directly in June, "Did that investor woman ever follow up?" And I said, "No, but I don't think it was malicious. I think she's probably just busy. Some of these people talk to 50 founders a month." I want to be clear about that because I think a lot of people watching this have done the same thing, extended someone the benefit of the doubt right up until the moment the evidence made doubt impossible. That's not a character flaw. That's just what trust looks like before it's been broken. The flaw, if there was one, was mine only in the sense that I hadn't protected myself with paperwork before extending that trust in the first place. I also spent part of that spring trying, unsuccessfully, to raise a small friends and family round on my own, around $40,000, which would have been enough to cover the full non-provisional patent filing and a first small production run. I got as far as a verbal yes from my uncle and a maybe from a former coworker before both of them independently pulled back, citing their own financial caution, nothing to do with me or the product. I remember feeling at the time like the universe was simply testing my patience. It didn't occur to me that the reason I felt like I was running out of time wasn't paranoia, it was that I actually was, and I just didn't know why yet. Meanwhile, unbeknownst to me, Corvale Home Goods LLC was quietly moving through its own timeline. Business filing records I pulled later showed the LLC registered in the state's Secretary of State database about 9 days after our meeting. A commercial lease for a small shared warehouse space was signed roughly 10 weeks after that. A seed funding round, I later learned it totaled $420,000 from a mix of angel investors and one small consumer products fund, closed a little over 4 months after our meeting, right around the time I was getting my second accelerator rejection. I read that press release 4 times before I let myself believe what I was looking at. It named a company I'd never heard of, Corvale Home Goods LLC. And it described, almost word for word, the market gap language I'd written myself on slide 6 of my pitch deck. The reusable food storage market, projected to hit north of $4 billion in the U.S. within 5 years. That statistic was mine. I pulled it from an industry report and cited it myself, right down to the source. The product photo in the press release showed a matte finish container with a cam lock lid. Not similar, not inspired by, the same latching geometry, the same 3-point stack alignment, the same accent color on the locking tab that I had chosen myself at a print shop from a Pantone swatch book because I liked how it looked against brushed aluminum kitchen counters. I remember sitting very still at my kitchen table for a long time. Then I did what I now recognize as the first genuinely useful thing I did in this entire ordeal. I didn't call Vanessa. I didn't post about it. I opened a blank document and I wrote down, with timestamps, everything I could remember. Then I went to my email and started pulling every message, every attachment, every calendar invite involving Vanessa Cole, and I saved them separately to a folder outside my regular inbox in case anything happened to that account. Here's what I was looking at once I actually let the numbers sink in. I had spent roughly $19,000 of my own savings on prototyping, tooling quotes, and provisional patent filing fees. I had turned down a part-time consulting contract worth about $30,000 over 6 months because I believed the VelaClip was about to get funded and I needed to focus on it full-time. I had 3 retail buyers, small specialty kitchen chains, not huge but real, who had expressed written interest in a pilot order once I had a manufacturing partner locked in. All 3 of those conversations went cold within weeks of Corvail's launch, because as one buyer told me directly over email, we already have a very similar product from Corvail in our spring lineup discussions. That valuation firm I mentioned at the start of this video, I hired them later during litigation to project what the VelaClip's revenue would likely have looked like over 3 years based on my actual retail conversations and manufacturing quotes. Their number was $2.4 million in projected value, net of costs, over that window. That's the number that ended up anchoring my damages claim. There was a relational cost, too, that doesn't show up on any damages spreadsheet, but was real all the same. I had told my parents proudly about the pitch meeting, about the investor who really got it. When Corvail launched, I had to call my mother and explain essentially that the exciting update I'd given her 9 months earlier had actually been the beginning of the worst professional betrayal of my life. She asked me gently, "Are you sure you're not misremembering how it happened?" Not because she doubted me, but because the whole thing sounded, even to me, too calculated to be real. I remember hanging up that call and sitting in my car in a parking lot for 20 minutes before I could drive home. Not because I was falling apart, but because I needed a few minutes where no one needed anything from me. I also lost something harder to quantify, the version of myself that trusted easily. I want to be careful not to overstate this into something maudlin, because ultimately this story has a genuinely satisfying ending. But for close to a year between the discovery and the settlement, I found myself rereading every email from every new business contact 3 or 4 times, looking for a version of the "is this deck basically the whole thing?" question, looking for the tell I'd missed the first time. That vigilance served me well eventually, but it also cost me some of the openness that had made building things enjoyable in the first place, at least for a while. But the financial damage wasn't even the part that kept me up at night. It was watching a woman I had trusted stand at a small business awards dinner 4 months later, accepting a Rising Entrepreneur Award, and describe, in her own words, on video, posted to Corvail's own social media, the moment of inspiration for the product. She told a story about her grandmother's kitchen. There was no grandmother's kitchen. There was a conference room, a PDF, and my slide 14. I watched that award video more times than I'd like to admit. In it, Vanessa stands at a podium holding a small glass trophy and tells a room of maybe 200 people about watching her grandmother struggle with stiff, cracked plastic lids every Thanksgiving, about promising herself as a teenager that she'd someday fix that problem, about finally bringing that childhood promise to life with Corvail's flagship product. The room applauds. Someone in the audience, visible for a second in the crowd shot, is wiping away a genuine tear. I remember watching that moment and feeling something close to nausea, because I recognized, instantly, the emotional structure of that story. It was almost beat for beat the kind of origin narrative I'd been coached by a pitch deck consultant I'd hired earlier that year to build around my own product. Except my version had been true, built around real user testing with real families, including, ironically, my own grandmother's real difficulty with stiff container lids. Vanessa hadn't just taken my mechanism. In that speech, she'd taken the emotional shape of my own story and repackaged it as hers in front of 200 people for an award. I did what I think most people would do first. I emailed her directly, calmly, on a Wednesday, laying out the timeline, our meeting, the pitch deck I'd sent her, and the striking similarity between Corvale's product and mine. I asked her, in writing, to explain the discrepancy, and suggested we talk before this became something neither of us wanted it to become. Her response came 4 days later from a different email address than the one she'd originally used with me. I'd find out later that was her new Corvale Home Goods business account, set up by that point with its own domain. She wrote that she was surprised and a little hurt by my accusation, that she and her product development team had independently arrived at a similar mechanical solution, because cam lock latches are a well-known engineering concept, and that she wished me luck with my own venture. Independently arrived. That phrase would come back to bite her harder than she could have imagined, because independent arrival is a real legal concept in patent and trade secret law, and it requires exactly what she did not have: her own documented design process predating any exposure to mine. I wrote back once more that same week, asking specifically whether she'd be willing to share any dated sketches, prototypes, or design notes that predated our March meeting, since that would go a long way toward resolving my concerns without either of us needing to involve attorneys. I never received a response to that email at all. Not a deflection, not a further explanation, nothing. In hindsight, I understand why. There was nothing predating our meeting for her to show me, and any attempt to fabricate something after the fact would have carried its own risks, given that digital files, as she would eventually learn the hard way, carry timestamps that are considerably harder to fake convincingly than most people assume. That silence, more than her one evasive email, was what finally pushed me from hurt and confused into building a case. An honest misunderstanding invites clarification. A guilty silence just sits there, unmoving, daring you to do something about it. I decided to do something about it. Once I started digging, and I mean really digging, pulling LinkedIn history, searching business filing databases, reading every word of Corvale's own marketing, I started to see the shape of what she'd actually done. She had formed Corvale Home Goods LLC 9 days after our meeting, 1 day after filing the provisional patent application. She'd brought on a co-founder, a manufacturing operations guy named in the LLC filing, who I have no reason to believe knew anything about where the design actually came from. He seemed, based on everything I could find, to be a legitimate operator who'd been sold a story about Vanessa's original invention. She'd also done something clever and cruel. She'd made small, cosmetic changes to the product between the provisional filing and the eventual retail launch. A slightly different color option, a modified lid thickness. Specifically, I believe, so that if I ever raised a complaint, she could point to those differences and claim the products weren't identical. It's a tactic I've since learned isn't uncommon. Change enough surface details to create the appearance of independent design, while keeping the actual protected mechanism, in her case the cam lock geometry from my slide 14, completely intact. There was another layer to the cover story too, which I only fully understood once I saw Corvale's early investor pitch deck during discovery, a document that, reading it, made my stomach turn in a way even the original press release hadn't. On slide 3 of her own investor deck, under a header that read "Our Origin," Vanessa had written a paragraph describing 18 months of independent research and prototyping before Corvale's formal launch. 18 months. Our meeting had happened at that point only about 5.5 months before that deck was created. She hadn't just borrowed my idea, she had fabricated an entire fictional development timeline stretching backward in time, specifically to make any future claim of derivation look implausible on its face. Because if investors believed she'd been quietly developing this for a year and a half, the idea of her deriving it from a single 90-minute meeting 5 months earlier would sound, to anyone not looking closely at actual dates, almost absurd. It very nearly worked. One of Corvail's actual seed investors, deposed later in the case, testified that Vanessa's long, patient development story was specifically part of what made him comfortable writing his check. He said he generally distrusted founders who seemed to have invented something overnight, because in his experience, durable products came from sustained iteration, not sudden inspiration. Vanessa, in other words, hadn't just stolen my product, she'd studied what makes investors trust a founder, and she'd built a false narrative specifically engineered to exploit that trust, using the actual 11-iteration development process I'd genuinely gone through, just relocated onto a fictional timeline of her own, and stripped of any reference to me. She was careful. She was not careless. She was smart enough to almost get away with it. And that's when I found the smoking gun. I want to explain this clearly because it's the single piece of evidence that changed the entire trajectory of this case, and it's something almost anyone in a similar situation can do themselves. When Vanessa filed her provisional patent application, her attorney submitted supporting technical drawings, diagrams of the cam lock mechanism, as part of the filing. Provisional patent applications, once a related non-provisional application publishes 18 months later or earlier upon request, become part of the public record through the USPTO's Patent Application Information System, known as PAIR, and later through Patent Center. I requested the file wrapper the moment Corvail's non-provisional application published. Inside that file wrapper were PDF technical drawings, and PDFs carry metadata, creation dates, modification dates, and sometimes, if whoever built the file wasn't careful, the software and even the original file name embedded in the document properties. I ran those PDFs through a metadata viewer. The creation date on the core drawing was 11 days before Vanessa's provisional filing date. That on its own wasn't damning. A patent attorney's office often needs time to prepare drawings. But the original file name embedded in the document properties was VelaClip_mechanism detail _slide 14_export.pdf. She hadn't just stolen the concept, her own attorney's office had, apparently without realizing what they were actually looking at, exported the technical drawing directly from a file that still carried my product's name in the file title. Someone on her side had taken my slide 14, cleaned it up for patent drawing standards, and never renamed the file before it got baked into the metadata of a federal filing. Have a strong case anymore. I had proof. I want to be honest about something. Finding one piece of damning metadata didn't make me reckless. If anything, it made me more careful, because I knew that if this ever ended up in front of a judge, I needed more than one data point. Coincidences happen. Cam lock mechanisms, as Vanessa's later legal team would correctly point out, aren't a novel category of engineering. They exist across dozens of unrelated patents going back decades. I needed to be able to show, cumulatively, that this wasn't a case of two people landing on a similar general concept independently, but a case of one specific, detailed, idiosyncratic implementation being copied wholesale. So over the following 2 weeks, I built out a side-by-side comparison document, 34 pages eventually, though it started much smaller. I measured the tolerances on my prototype's locking tab against publicly available product photos of Corvail's release version, using nothing more sophisticated than a caliper and a lot of patience. I found that the tab width matched mine to within 0.5 millimeter. I compared the 3-point stacking geometry, a detail I'd chosen specifically to solve a shelf space problem I'd identified after user testing with 6 families in my own social circle. Corvail's product had the same 3-point geometry in the same orientation. I also went back through Vanessa's own public social media history, archived versions of her posts using the Wayback Machine, and I found something that mattered more than I expected it to, a post from 2 years before we'd ever met, in which she'd talked generally about the future of sustainable kitchen products without a single reference to cam lock mechanisms, modular stacking, or anything resembling the VelaClick specific engineering. If she'd truly been developing this idea independently over time, as her later legal filings would claim, I expected there to be some trace of that development somewhere in 2 years of fairly active posting about her professional interests. There wasn't. The idea, in her own public record, appeared to begin exactly where mine ended, right around our March meeting. None of this was, on its own, a knockout blow, but stacked together, the metadata, the tolerance measurements, the timeline gap, the absence of any prior public trace of her supposedly independent development, it stopped looking like coincidence and started looking like exactly what it was. Finding that metadata didn't end the investigation, it started the real version of it. Up to that point, I'd been reactive, collecting emails, saving screenshots, trying to protect myself. Now, I understood I needed to build something that could survive contact with a courtroom, a patent examiner, or both. So I did something I'd never done before in my life. I built a formal timeline, a real evidentiary record, the way I imagined the people on true crime shows did it. Except the crime here didn't leave a body, it left a paper trail. Which, honestly, is even better, because paper trails don't lie and they don't get nervous on the witness stand. I bought a corkboard. I know how that sounds, but stay with me because it worked. I printed out every dated document I had. The pitch deck email from 4:47 p.m. in March, the provisional patent filing date 8 days later, the LLC formation date 1 day after that, the metadata report from the technical drawings, the awards dinner video where she described her fictional grandmother's kitchen, the retail buyer emails going hold. I laid it all out in chronological order, and I could see, physically in front of me, the 8-day gap between I trusted her with my idea and she filed a patent on my idea. I want to be honest about something most of these stories skip over. Finding the right lawyer took me 3 tries. The first attorney I consulted was a general business litigator who quoted me a retainer of $15,000 and, frankly, didn't seem to fully understand the difference between patent infringement and trade secret misappropriation, 2 related but legally distinct claims that mattered enormously to my case. The second attorney I spoke with, on the recommendation of a friend who'd gone through a trademark dispute, was better, but her firm didn't have in-house patent litigation experience, which mattered because part of my strategy would eventually require challenging Vanessa's inventorship at the USPTO itself, not just suing her in civil court. The third attorney, a woman named, I'll just call her my IP litigator, ran a boutique intellectual property firm that specialized in exactly this kind of dispute: founder versus founder theft, patent inventorship fights, trade secret claims under both state law and the federal Defend Trade Secrets Act. She looked at my corkboard photos, I'd taken pictures because I wasn't about to lug a corkboard into her office, and she said something I'll never forget. This isn't a case where we need to prove she's a bad person. This is a case where the dates prove themselves. Our job is just to make sure the right people see them in the right order. I want to describe that first meeting with her a little more because I think it's useful for anyone who ever finds themselves in a similar position and doesn't know what a good fit with an attorney actually feels like versus a bad one. The first attorney I mentioned spent most of our consultation talking about his own past case results, in general terms, without asking me many specific questions about mine. The second attorney was warm and attentive, but kept saying things like, we'd probably need to bring in outside patent counsel for that piece, which, in hindsight, was her being honest about the limits of her expertise, which left me with the uncomfortable sense that my case would be handled by a rotating cast of specialists rather than one person who truly understood the whole picture. My eventual IP litigator did something different. She asked me, before I'd even finished laying out the full timeline, do you have the original email you sent her with the pitch deck attached? Not a description of it, the actual email with headers intact. I hadn't even thought about email headers before that point. I told her I did, or that I believed I did, and she said, good. That's the single most important document in this entire case, and I need you to send it to me before you leave this building, from your own email account, not forwarded, not copy-pasted, the original, so we preserve the metadata on our end too. That level of specificity, that immediate instinct toward evidentiary preservation rather than general reassurance, is what told me I'd finally found the right person. Her retainer was $12,000 to start, with the understanding that this was likely to become a multi-track case, a derivation proceeding at the USPTAO's Patent Trial and Appeal Board, known as the PTAB, to challenge Vanessa's claim to sole inventorship, running in parallel with a civil lawsuit for trade secret misappropriation, breach of confidence, and unjust enrichment. This part matters because I think most people don't know it exists, and it's one of the most powerful tools available if you're ever in this position. Since 2013, when the America Invents Act shifted the U.S. patent system to a first inventor to file framework, the USPTAO has had a formal process called a derivation proceeding. It exists specifically for situations like mine, when a patent application names an inventor who actually derived the claimed invention from someone else without that person's authorization and then filed on it first. To bring a derivation proceeding, we had 1 year from the date Corvail's application was first published to file our petition, and we had to show, with particularity, that Vanessa had communicated the invention to herself, meaning that she'd received it from me, without my authorization to file on it. My IP litigator built the petition around exactly the evidence on my corkboard, the time-stamped email with the pitch deck attached, the 8-day gap, the metadata from the technical drawings still bearing my product's file name, and a sworn declaration from me describing our meeting in detail. We filed the petition with the Patent Trial and Appeal Board. Filing fees for a derivation proceeding aren't small. Ours ran a little over $12,000 just in US PTO fees, on top of attorney time to prepare it, but compared to what was at stake, it was the clearest path forward. My IP litigator was upfront with me that derivation proceedings are relatively rare, and rarer still to succeed, precisely because most petitioners can't produce the kind of dated, corroborated evidence the board requires. She told me, in our first strategy meeting, most people who come to me with a story like yours have the story but not the paperwork. You have both. That's what makes this winnable. She walked me through what the board would actually be looking for: clear and convincing evidence, a higher bar than the preponderance of the evidence standard used in most civil cases, that Vanessa had both received the invention from me and used it without my authorization in her own filing. Clear and convincing evidence is a meaningfully higher bar, and I remember feeling the weight of that the first time she explained it. This wasn't going to be a case decided on gut feeling or general suspicion. Every piece of my corkboard needed to hold up on its own. We spent almost 6 weeks just preparing the petition itself, drafting my sworn declaration, cross-referencing every date against independent documentation, email server timestamps, the USPTO's own official filing date records pulled directly from Patent Center, the metadata report formatted by a digital forensics consultant we brought in specifically to authenticate the PDF properties in a way that would hold up if challenged. That consultant's fee alone was about $4,000, and it was worth every cent, because when Vanessa's attorney later tried to argue the metadata could have been altered or was unreliable, we had an independent, credentialed forensic analysis standing behind it, not just my own read of a file properties window. At the same time, we filed a civil complaint in federal court because a derivation proceeding, even if we won it, would only resolve who the rightful inventor was. It wouldn't compensate me for the actual financial harm. The civil complaint alleged trade secret misappropriation under the Defend Trade Secrets Act, breach of an implied duty of confidentiality, since even without a signed NDA, courts in many jurisdictions recognize that sharing confidential business information under circumstances implying trust can create an enforceable duty, and unjust enrichment, meaning Vanessa and Corval had profited from something that wasn't theirs to profit from. Vanessa's response, once she was served, went through her own attorney, and it followed a pattern I've since learned is extremely common. Deny everything, characterize the relationship as purely informal networking, argue that cam lock mechanisms are well known in the prior art and therefore not a protectable trade secret at all, and file a motion to dismiss. That motion to dismiss is where I had my first real scare. Her attorney argued with some real legal sophistication that because cam lock latching mechanisms in general did exist in prior patents, which was true in a broad sense, my specific implementation wasn't protectable as a trade secret, and that I hadn't taken reasonable measures to maintain its secrecy, since I'd shared the full pitch deck over an unencrypted email without a signed NDA. Under trade secret law, reasonable measures to maintain secrecy is a real requirement, and the absence of an NDA was a genuine vulnerability in my case. For about 6 weeks, I genuinely believed this could end in dismissal. My IP litigator was more confident than I was. She pointed out that reasonable measures doesn't require perfection, and that the specific combination of design elements, tolerances, and the exact geometry of my cam lock, not the general concept, but my particular engineering solution to it, was what we were claiming as the trade secret, along with the pitch deck's confidential market analysis and manufacturing quotes, which had nothing to do with prior art at all.
The judge denied the motion to dismiss in a written order that, reading it, felt like the first moment the outside world actually validated what I already knew. The timeline itself created what the court called a plausible inference of derivation and misappropriation sufficient to proceed to discovery. Discovery is where cases like this are actually won or lost, and it's also where I finally understood what had really happened, layer by layer. Through discovery, my attorney was able to depose Vanessa Cole under oath, and also to subpoena internal Corval emails and files from her patent attorney's office regarding the preparation of the technical drawings. The deposition transcript, and I still have it, shows Vanessa, under oath, repeatedly unable to explain the design process for the cam lock mechanism she claimed to have invented independently. When asked to describe any sketches, prototypes, or engineering notes predating our March meeting, she could produce none. When confronted with the metadata showing the drawing's original file name referencing Vila Clip de Mechanism Detail Slide 14 Export.pdf, her attorney, verbatim, was, "I don't have an explanation for that. That would have been something my design consultant handled." I want to walk through more of that deposition because reading it later felt almost cinematic in a way I never expected a legal transcript to feel. My attorney asked her directly, "Miss Cole, can you describe for the record the first time you conceived of a cam-actuated lock-in mechanism for a stackable food storage container?" There's a long pause noted in the transcript. The court reporter actually wrote, "Witness pauses," before Vanessa answered that it had been an evolving concept she'd been thinking about for a while. When pressed to give an actual date, any date, she offered sometime in the winter, which, once cross-referenced against the timeline, would have placed her independent conception after our March meeting, not before it, an inconsistency my attorney let sit in the record without comment, because sometimes the most effective cross-examination is simply giving someone enough room to contradict themselves. Later, in the same deposition, my attorney walked her through the metadata evidence directly, asking her to explain the file name VLAClip de mechanism detail slide 14 export.pdf. Vanessa's attorney objected on the grounds that she wasn't a technical witness qualified to explain PDF metadata, which was true, but it didn't change the fact that the file existed, had been submitted as part of her own patent application, and bore my product's name. The objection was preserved for the record, but it didn't make the file name disappear. The design consultant she referenced turned out to be a freelance CAD drafter she'd hired the week after our meeting, a young engineer who, once subpoenaed himself, testified that he'd been handed what he was told was the client's own conceptual sketch to formalize into patent-ready drawings, and that he had no reason at the time to believe it belonged to anyone but Vanessa. He was, in other words, an innocent party who'd unknowingly formalized my stolen idea into a federal filing. His testimony, rather than hurting my case, actually strengthened it because it closed off Vanessa's last remaining argument that maybe someone else on her team had come up with the design independently. There was no one else. There was only my slide 14, laundered through a freelancer who had no idea what he was actually looking at.
That was, without question, the moment I knew this case was no longer a question of if I'd win, it was a question of how much. I said earlier there was a near miss with the motion to dismiss. There was a second one later during discovery itself that I think is worth including because it's the kind of moment these stories often skip over in favor of a clean narrative arc, and I don't want to give you a clean narrative arc. I want to give you what actually happened. About midway through discovery, Vanessa's attorney made a settlement offer far smaller than anything we'd end up accepting, $150,000, contingent on a non-disclosure agreement covering the entire dispute, meaning I would never have been able to talk about any of it publicly, including this video not existing at all. I was tired. Litigation, even when you're winning, is exhausting in a way that's hard to describe until you've lived through it. The depositions, the document review, the constant low-grade anxiety of wondering whether a judge somewhere might see something differently than your own attorney does. For about 4 days, I genuinely considered taking that offer just to make it stop. My IP litigator didn't pressure me either way. She was careful about that, and I respect her for it. But she did ask me one question that changed my mind. If you take this now, sign the NDA, and Vanessa goes on to do this to someone else next year, how will that sit with you? I didn't have a good answer. I turned the offer down. 3 weeks later, the CAD drafter's deposition happened, and everything I described a moment ago came out into the open. That $150,000 offer, in hindsight, is the clearest evidence I have that Vanessa's side knew, even before formal discovery was complete, exactly how bad their exposure actually was. There's one more piece of the investigation I haven't mentioned yet, because my attorney and I debated it carefully before doing it. At a certain point, roughly 2 months into the civil case, we made a calculated decision for me to post, carefully, factually, without naming Vanessa or Corvalet directly, a short professional update on LinkedIn describing that I was pursuing a formal inventorship dispute regarding a consumer product concept, and that I welcomed contact from anyone with relevant information. My attorney was adamant that the post avoid any defamatory language, stick strictly to verifiable fact, and make no direct accusation before a court had ruled on anything. That post did something I didn't fully expect. It surfaced a witness. A woman who had briefly consulted for Corvalet in its earliest months, doing some freelance packaging design work, unrelated to the mechanism itself, messaged me privately. She told me that during a team meeting she'd sat in on, Vanessa had referred offhand to the founder we got this from, before quickly changing the subject when she noticed the consultant's confused expression. The consultant hadn't thought much of it at the time. She assumed it meant Vanessa had licensed the concept from someone, which happens legitimately all the time in product development. But once she saw my LinkedIn post, months later, the comment suddenly made a lot more sense to her, and she agreed to provide a written declaration describing what she'd heard. I want to be fair to her and to anyone else who might find themselves adjacent to a situation like this without knowing it. She wasn't complicit in anything, and I never treated her as though she were. She'd taken a short-term freelance contract, done honest work on packaging, typography, and color choices completely unrelated to the mechanism itself, been paid fairly and on time, and moved on to other clients. It would have been easy, in my anger, to treat everyone who'd ever touched Corvail as somehow tainted by association. My attorney cautioned me strongly against that instinct, both because it wasn't fair and because it would have actively hurt my case. Witnesses who feel accused rather than simply asked tend to become defensive, unhelpful, or hostile, whereas witnesses who are treated as exactly what they are, people with a small piece of relevant information and no reason to lie, tend to become genuinely useful. That distinction, small as it sounds, shaped how I approached every single person I spoke to during this entire process, and I think it's part of why so many of them were willing to help. That declaration wasn't, on its own, a smoking gun the way the metadata was, but it corroborated the timeline. It corroborated that Vanessa herself, in an unguarded moment, had referred to the invention as having come from someone else, the grandmother we got this from, rather than from her own independent process. My attorney later told me that witness statements like that one, even when imperfect, matter enormously in these cases because they show a pattern consistent with the documentary evidence rather than contradicting it. Judges and administrative boards don't expect a single perfect piece of evidence. They look at whether everything fits together into one coherent, internally consistent account. By that point, mine did, and Vanessa's didn't. I also want to mention, because I think it's useful for anyone else in this position, that we briefly explored filing a complaint with the Federal Trade Commission regarding the potentially deceptive nature of the grandmother's kitchen origin story used in Corvail, since the FTC does have authority over deceptive trade practices in advertising. Ultimately, my attorney advised that the FTC route was unlikely to move quickly enough to matter for my specific damages, and that our resources were better spent focused on the PTAB proceeding and the civil case, which had direct, binding authority to actually make me whole. We didn't pursue it further, but I mention it because I think it's worth knowing that avenue exists, even if it wasn't the right one for my situation. Between filing the derivation petition and getting a decision, there was a stretch of nearly 8 months where, functionally, nothing visible happened at all. Administrative proceedings like this move on their own institutional clock, and my attorney was honest with me from the outset that PTAB decisions typically take the better part of a year, sometimes longer if the board requests supplemental briefing. That waiting period was, in some ways, harder on me psychologically than the discovery process itself, because discovery at least felt like forward motion, depositions, subpoenas, new documents landing in my inbox every few weeks. The waiting period was just silence, punctuated occasionally by a procedural notice confirming that the case was still, technically, alive. I filled that silence by continuing to build. I didn't stop developing the Vila clip just because its fate was tied up in a federal proceeding. I kept refining the design, kept talking to my Ohio manufacturer, kept a running list of every retail buyer relationship I intended to reapproach the moment I had clear legal standing to do so again. My attorney told me once, during a routine check-in call where I admitted I was struggling with the uncertainty, the waiting is the price of doing this properly instead of doing this loudly. Loud gets you attention. Quiet, documented, and patient gets you a result that actually holds up. I've thought about that line more times than I can count since. The derivation proceeding at the Patent Trial and Appeal Board concluded first, based on the evidentiary record, my sworn declaration, the time-stamped pitch deck email, the 8-day gap between our meeting and her provisional filing, the CAD drafter's testimony, and the metadata evidence. The board issued a decision finding that Vanessa Cole had derived the claimed invention from me without authorization. The practical effect of that ruling was significant. It meant Corvail's patent application could not proceed with Vanessa listed as the inventor, and it opened the door for me, if I chose, to pursue my own patent rights on the underlying invention with the priority benefit of my earlier disclosure. I want to pause on what that actually means in plain terms, because derivation proceeding can sound abstract. What it meant, concretely, was this: a woman who had spent the better part of a year publicly presenting herself as the inventor of the Vila clip, accepting an award for it, building a company around it, telling a fabricated story about her grandmother's kitchen, now had a federal administrative ruling on record stating that she was not the inventor, that I was. I remember the exact moment my attorney called to tell me the decision had come down. I was standing in my kitchen, of all places, next to the exact drawer where an early foam core prototype of the Vila clip had lived for months before I'd ever met Vanessa Cole. My attorney read me the key line from the board's written decision over the phone, that the evidence clearly and convincingly establishes that the named inventor derived the claimed subject matter from the petitioner, and that such derivation was without authorization. I asked her to read it again. She did. I sat down on my kitchen floor, phone still against my ear, and I cried in a way I hadn't let myself do at any point during the entire process up to then, not out of sadness, but out of something closer to relief so total it had nowhere else to go. With the derivation ruling in hand, Vanessa's leverage in the civil case collapsed almost overnight. Her attorney reached out to mine within about 3 weeks requesting settlement discussions, which, if you've ever been through litigation, is usually a sign that the other side's own counsel has told them, privately, that trial is now a significantly worse option than settling. We went through 2 rounds of mediation. The first offer from Vanessa's side was $800,000, which her attorney framed as generous. My IP litigator advised me to reject it, not out of spite, but because our damages expert's report, incorporating the $2.4 million projected valuation, the $19,000 in out-of-pocket costs, the lost consulting income, and a claim for unjust enrichment based on Corvail's actual seed funding and early revenue, supported a much stronger position. The final settlement, reached after the second mediation session, totaled $3.2 million, structured as a combination of a lump sum cash payment, an assignment of Corvail's patent rights, and pending applications related to the cam lock mechanism back to me, and a public retraction, a joint statement drafted with both attorneys' involvement, correcting the inventorship record and formally crediting me as the original creator of the design. $3.2 million against $19,000 in direct out-of-pocket losses and roughly $180,000 in total legal fees across both the PTAB proceeding and the civil case. Even after fees, after taxes, after everything, this settlement transformed my financial life in a way that 11 months of exhausting, careful work never got the chance to on its own, because someone else took that chance from me first. I want to break down where that number actually came from, because I think the mechanics matter, and because I think a lot of people assume settlements like this are somewhat arbitrary, a negotiation that lands wherever both sides get tired of arguing. Ours wasn't arbitrary. It was built, line by line, from our damages expert's report. The $2.4 million figure represented projected lost profits over a 3-year window. discounted to present value using a methodology the expert testified was standard in early-stage consumer products valuation, based on my actual documented retail conversations rather than speculative market share assumptions, a distinction that matters enormously in this kind of litigation, because courts are generally skeptical of damages built on hypothetical, we could have captured 5% of a $4 billion market logic, and much more receptive to damages built on real, named retail buyers who had expressed real, documented interest before the theft occurred. On top of that projected loss figure, we had a separate unjust enrichment claim, which entitled me to recover profits Corvalle had actually made as a result of misappropriating my design. A distinct legal theory from lost profits, because it doesn't require proving what I would have earned, only what they did earn using something that wasn't theirs. Corvalle's own financial records, produced in discovery, showed just over $1.1 million in gross revenue in its first 18 months, with the Camlock product line responsible for the substantial majority of that. Building that damages report meant bringing in a forensic accountant, separate from the digital forensics consultant who'd authenticated the metadata. She specialized in early-stage business valuation and had testified as an expert witness in intellectual property cases before, which mattered because Vanessa's attorney would inevitably challenge her methodology, and a shaky expert with no track record could have undone months of careful work in a single cross-examination. She spent about 6 weeks building her report, working from my retail buyer correspondence, my manufacturing quotes, comparable market data for similar consumer products that had successfully launched in the reusable storage category, and Corvalle's own produced financial records. She was blunt with me early on. I can't give you a number that assumes you definitely would have succeeded. I can give you a number that reflects what a reasonable buyer of this business, looking at exactly what you had in hand at the moment of the theft, would have paid for it. That distinction, not what you dreamed of, but what a reasonable buyer would pay for exactly what existed, became the backbone of a report that held up under scrutiny, precisely because it didn't overreach. Between the lost profits claim, the unjust enrichment claim, and a request for enhanced damages under the trade secret statute, which allows courts to award up to double the base damages in cases of willful and malicious misappropriation, a standard my attorney argued the metadata evidence alone was sufficient to meet, our total demand going into mediation was actually closer to $4.6 million. The $3.2 million figure represented the negotiated middle ground once Vanessa's side factored in the cost, risk, and public exposure of taking a case with this evidentiary record all the way to trial. I also want to walk through how the settlement itself was structured, because $3.2 million as a headline number obscures some details that I think are genuinely useful for anyone who ever finds themselves negotiating a resolution like this. The settlement wasn't paid as a single lump sum on day one. It was structured as 40% due within 30 days of the signed agreement, another 30% due within 90 days, and the remaining 30% due within a year, secured against a lien on Corvalle's own business assets in case of default, a protection my attorney insisted on, because a defendant agreeing to pay a large settlement is not the same thing as a defendant who will actually pay it on schedule without some enforcement mechanism attached. That structure mattered. Vanessa's remaining personal and business liquidity, according to financial disclosures made during settlement negotiations, couldn't have supported a single immediate lump sum payment of that size without forcing either a sale of Corvalle itself or a personal bankruptcy filing, neither of which served my actual goal, which was to get paid in full, not to watch the company collapse into a bankruptcy proceeding where I'd become just one more unsecured creditor in line. The patent assignment piece was its own negotiation entirely, Rather than simply abandoning Corvail's pending application, the settlement required a formal assignment of all rights, title, and interest in the application, along with any foreign filings that had been made under the Patent Cooperation Treaty, since Vanessa's team had, I later learned, also begun an international filing process in 2 additional countries, back to me, recorded with the USPTO's Assignment Recordation Branch so the correction would be permanent and publicly searchable, not just a private side agreement between us. We also negotiated a limited, time-boxed non-compete provision, preventing Vanessa personally, though not Corvail's other employees or the manufacturing operations co-founder, from launching any directly competing cam lock sealing product for a period of 3 years. My attorney was careful to keep this narrow enough to survive scrutiny. Overly broad non-competes can be unenforceable in many states, but specific enough to actually protect the market I was re-entering.
Part of the settlement, a part I insisted on honestly more than the money, was that joint statement. Corvail Home Goods issued a public correction acknowledging that the original design concept for their flagship product had been developed by me, and that inventorship of the associated patent application had been formally corrected through USPTO proceedings. It wasn't a dramatic public shaming, these things rarely are, but it existed, in writing, publicly, permanently searchable. Vanessa Cole's name is now attached, in the public record, to a derivation proceeding she lost. She stepped back from a public-facing role at Corvail within about 4 months of the settlement. I don't know all the internal details of why. I wasn't inside those conversations, but I do know that once investors and retail partners could search her name and find a federal ruling stating she had derived a patent claim from someone else without authorization, her credibility as a founder took a hit that no press release could undo. There were no criminal charges in my case. Trade secret theft between private individuals, absent something like hacking or physical theft of protected materials, often lives in civil court rather than criminal court, and my attorney was upfront with me from the start. I did, out of thoroughness, consult briefly with a former federal prosecutor about whether anything in my fact pattern might rise to the level of wire fraud, given that emails and interstate communications were involved, or a criminal trade secret theft claim under the Economic Espionage Act, which does have a criminal enforcement mechanism in certain circumstances. His assessment was candid. Federal criminal resources in this area are generally reserved for cases involving significant national economic harm, foreign actors, or particularly egregious, well-documented theft affecting major corporations, and a single-founder civil dispute like mine, however clear-cut the evidence, was extremely unlikely to attract prosecutorial interest, especially once a strong civil remedy was already available and moving forward on its own. I appreciated his honesty rather than being told what I might have wanted to hear. What I got instead was something I actually think mattered more, in the specific and complete way it mattered: a legally binding, publicly documented correction of the truth, a federal administrative ruling with my name in it as the rightful inventor, and a settlement large enough that it was impossible to characterize what happened as some kind of misunderstanding, a difference of recollection, or an innocent parallel invention. Some cases need a prosecutor and a jail sentence to feel resolved. Mine needed the truth to be officially, permanently, searchably on the record, and it needed to cost Vanessa Cole more than she ever thought this would cost her. Both of those things happened. Here's the detail that still sits strangely with me months later. During discovery, we learned that a significant portion of Corvail's initial seed funding, the 6-figure seed round from that original press release, hadn't gone toward manufacturing scale-up or marketing at all. Roughly 60% of it had gone toward Vanessa's own compensation and consulting fees paid to herself through a separate LLC she controlled, structured as management fees billed back to Corvail.
In other words, this was never really about believing in a grandmother's kitchen, or even really about building a great company. Based on everything that came out in discovery, it looked a great deal like a pattern. Identify a promising early-stage founder without the resources yet to protect their own idea, extract the idea under the guise of mentorship, file on it fast before the original inventor could, build just enough of a company around it to attract seed funding, and pay yourself well along the way. I was, as far as I could determine through the litigation, not her only encounter with this playbook, though I can't confirm that with certainty, and I'll leave that where it is. During one deposition exhibit, we came across an internal Corval Home Goods budget spreadsheet produced under subpoena that broke down the use of that $420,000 seed round in granular detail. Roughly $250,000 was categorized under founder compensation and strategic consulting, paid out over 14 months to an LLC with Vanessa listed as the sole registered agent. Product development, tooling, materials, engineering contractor fees accounted for a little under $90,000. Marketing, including the awards dinner sponsorship and the press release distribution service, ran close to $40,000. The remaining balance covered the warehouse lease and general operating costs. When my attorney walked her through those numbers during the deposition and asked her to explain the discrepancy between the money raised to build a revolutionary product and the roughly 60% of it that went to paying herself, Vanessa's answer, according to the transcript, was that founders are entitled to fair compensation for their labor and vision. The word vision landed strangely in that room, given everything else already on the record by that point. For anyone wondering, Corval Home Goods LLC still exists, technically, under the manufacturing operations co-founder's leadership, though it no longer sells anything resembling the original Camlock product line, since those rights in the associated patent assignment now belong to me. The company pivoted to a smaller line of unrelated kitchen organization products. I have no ill will toward that co-founder specifically. Everything I saw in discovery suggested he'd been genuinely misled about where the core invention came from, and he cooperated fully once the truth became clear, which I respect. Sometimes the person standing next to a fraud is just someone who trusted the wrong partner too, in a smaller, less costly version of exactly what happened to me. I used part of the settlement to finally file the full non-provisional patent application on the VelaClip, under my own name this time, with airtight documentation of inventorship going back to my original prototype notes. I relaunched under a new company name. I still work with the manufacturing partner in Ohio. The product is on shelves now in more stores than I originally pitched.
But I do things differently now. Every single person I bring into a conversation about a product idea signs an NDA before they see anything beyond a one-page teaser. I file provisional patents earlier, even when it strains the budget, because 11 days is apparently all it takes for someone to turn your own file into their own patent application. I keep dated, time-stamped design records for everything, not because I expect to be betrayed again, but because I now understand that the paper trail isn't paranoia, it's protection. I also do something now that I never used to do. I mentor other early-stage founders, specifically on this exact vulnerability, usually for free, sometimes for a small fee that I mostly donate to a legal aid organization that helps small inventors who can't afford a $12,000 retainer. I've sat across the table from probably 24 founders at this point, walking them through the same red flags I missed: the refusal to sign an NDA, the request for full technical detail before any real commitment, the vague "let's do this together" language with no term sheet attached. A few of them have thanked me for probably saving them from a version of what happened to me. I don't know if that's true in every case, but I like to think that somewhere in that group, at least one VelaClip is still safely, quietly sitting in its own name because of a conversation we had. As for Vanessa Cole, I genuinely don't spend much time thinking about her anymore, which surprised me because for a long time I assumed the anger would be the last thing to fade. It wasn't.
What lasted was something closer to clarity, an understanding of exactly what I'm building, exactly who I let close to it, and exactly what I do immediately, dated and documented, the moment a new idea is worth protecting. That clarity is worth more to me now than the settlement check ever was, even though, to be completely honest with you, the settlement check was also very, very nice. I tell this story not because I want you to distrust every investor, every mentor, every person who offers to help founders. Most people who offer to help founders are exactly who they say they are. But I want you to know what the warning signs actually look like, because I missed almost every one of mine, and I don't want you to. Watch for someone who refuses to sign an NDA and frames that refusal as a sign of trust or authenticity. A legitimate advisor or investor is used to signing confidentiality agreements. It's a routine part of how serious business is done, not an insult. Watch for anyone who wants full technical detail before making any concrete commitment, a term sheet, a formal advisory agreement, anything with actual terms attached. Vague enthusiasm without paperwork is not the same as a real offer. File your provisional patent application as early as your budget allows, even if it feels premature. And once you do, move toward the full, non-provisional filing as fast as you realistically can. That window between provisional and non-provisional is exactly where I got exposed. Keep dated records of everything. Emails with timestamps, design files with clear version histories. If you ever do end up needing to prove a timeline to the USPTO, to a court, to anyone, the difference between having that record and not having it is the difference between a case that resolves in months and one that drags on, or worse, one you lose entirely because you can't prove what you already know is true. Let me give you a slightly more structured version of this, because I think it's genuinely useful, not just a list of vague cautions. First, on documentation, use a dated engineering notebook, physical or digital, and never go back and edit old entries. Add new dated entries instead, the way a lab notebook works. Services exist that timestamp digital files against a blockchain or a trusted third-party timestamp authority, specifically so you can later prove a file existed at a certain point in time without relying on your own computer's easily alterable metadata. I use one now for every major design milestone. Second, on legal protection. A provisional patent application, while cheaper than a full non-provisional filing, still gives you an official USPTO filing date and a 12-month window of patent pending status, during which you can more safely discuss your invention. It is not a substitute for an NDA in a business conversation, but it is a real, low-cost first line of defense, and I'd encourage anyone with a genuinely novel mechanical or technical invention to talk to a patent attorney about filing one earlier than feels financially comfortable, rather than later. Third, on due diligence toward the other side. Before you share anything sensitive with an advisor or investor, search their name alongside terms like lawsuit, dispute, or complaint. Look at how long they've actually been operating in the space they claim expertise in. Ask for references from founders they genuinely helped, and then actually contact those references, rather than taking a name drop at face value. Vanessa Cole had, as far as I could later determine, no verifiable track record of actually helping any of the founders she claimed to have worked with. Those claims simply hadn't been tested by anyone before me. Fourth, on structuring conversations, it's entirely reasonable to share a high-level summary, market opportunity, general product category, business model, without sharing your specific technical implementation, your full financial projections, or your manufacturing quotes until a real binding relationship exists. If someone pushes hard for full technical detail before offering any real commitment in return, that imbalance itself is information. Legitimate investors are used to phased disclosure. It's how the entire venture ecosystem is designed to work, precisely because ideas are vulnerable in exactly this way. And if something ever feels off, If someone's story about your own product starts to sound too polished, too rehearsed, too convenient, trust that instinct enough to start documenting quietly before you ever confront anyone. I built my entire case in the 6 weeks before I said a single word to Vanessa Cole about what I suspected. That head start mattered. One more thing, and then I'll let you go. If you ever find yourself in a version of this situation, staring at a press release or a product listing or a social media post that looks unmistakably like something you built, resist the urge to confront the person publicly in the first hour of finding out. I understand the impulse. I felt it too, sitting at my kitchen table that Tuesday morning, wanting to fire off a furious message immediately. But the version of me that waited, that spent 6 quiet weeks building a corkboard instead of sending an angry email, is the version of me that eventually got $3.2 million and a corrected federal record. The version of me that reacted in the first hour would have tipped my hand, given Vanessa time to clean up whatever she could, and probably cost me the metadata discovery entirely, since patent applications and their supporting drawings aren't always immediately public. Mine only became available to me once her application published, and I didn't rush that process by making noise too early. Have you ever had someone try to take credit for your work, your idea, or your business? I want to hear what happened. Drop it in the comments below. And if you've got documentation of your own experience, I genuinely encourage you to write it down, dated today, even if you never end up needing it. Most of the people I've since talked to who successfully protected themselves in situations like mine didn't do it because they were smarter than the person trying to take advantage of them. They did it because, at some point, often for reasons that felt unrelated at the time, they'd already built the habit of writing things down. If this story kept you watching this long, there are more like it on this channel every week. Real financial fraud, real investigations, real justice, told the way they actually happened, with the numbers, the dates, and the paperwork that made the difference between a founder who got taken advantage of and stayed that way, and a founder who got every single dollar back. Subscribe, and I'll see you in the next one.